Hello and welcome to today's webinar on Property Management Redress Schemes, what leaseholders need to know. This is part of our occasional series of free recorded webinars covering different topics on leasehold law. My name is Kavita Bharti and I'm a lease advisor working for the Leasehold Advisory Service. The webinar is scheduled to last about 20 minutes. If you have any further queries, you can email any inquiries to us. Our email address is info@lease-advice.org. Currently, there are 4.1 million leasehold dwellings in England. Around 40% of new build property in England is leasehold, and it's estimated around a maximum of 1,500 leasehold management agents. These leaseholders tend to come up against these managing agents in relation to a variety of issues. The main types of issues raised by leaseholders to the Leasehold Advisory Service are usually in relation to service charges, application to the first tier tribunal property chamber, lease extensions, freehold purchase and management. Obviously, other issues do come up, such as repairs, statutory consultation, breaches of covenant, interpreting leases and the right to manage. Examples of some of these issues are things like the managing agent not picking up the phone or responding to basic queries. Previously, there wasn't really anywhere to go with these issues. There was a major gap, especially as not everybody was required to be a member of a redress scheme. It's the government's intention to ensure that all agents are required to belong to a redress scheme that has been approved by the Secretary of State or is administered by or on behalf of the Secretary of State. The intention is that there will be only approved schemes, although the Secretary of State may choose to set up a government-administered scheme if the approved schemes are unable to offer a place to every agent who would be subject to the duty to belong to a scheme. Under Section 83, subsection 2 of the Enterprise and Regulatory Reform Act 2013, the definition of a redress scheme is a scheme which provides for complaints against members of the scheme to be investigated and determined by an independent person, for example, an ombudsman. Section 84, subsection 6, defines property management work as things done by any person, A, in the course of a business, in response to instructions received from another person, C, where C wishes A to arrange services, repairs, maintenance, improvements or insurance to deal with any other aspect of the management of premises in England on C's behalf, and the premises consists of or includes a dwelling house let under a relevant tenancy. Property management work does not include things done by a person who is a social landlord for the purposes of Schedule 2 of the Housing Act 1996. A social landlord would be classed as either a local housing authority that are registered providers of social housing or private registered providers of social housing. Social landlords are already under a duty to belong to a redress scheme called the Housing Ombudsman Services. I've put a link to their website on that slide there. ALMOs, Arm's Length Management Organisations, are also included within this bracket. Property management work would arise where a landlord has instructed an agent to manage a house let to a tenant in the private rented sector, or where an agent-managed block contains flats which are let under a long lease or to assured or protected tenants. The Secretary of State has power under Section 87 of the 1993 Act to approve a code of management practice concerned with the management of residential property by landlords and managing agents. All managing agents should follow these codes, which, although are not legislation, they are admissible as evidence in courts and tribunals, and where relevant, they will be taken into account in proceedings. A redress scheme, therefore, still has to consider the application of these codes. The current codes of practice are the RICS Rent-Only Residential Management Code, the RICS Service Charge Residential Management Code, and the ARHM Code of Management Practice for Private Retirement Housing. As I mentioned within the previous slide, all managing agents should follow these codes. One of the rules under Part 20 of the RICS Code, the Service Charge Residential Management Code, is to have an internal complaints procedure. Now, if you have any issues with your property manager, you should always follow your property manager's internal complaints procedure first. But if you're not satisfied with that outcome, you can seek redress through one of the approved schemes, which I will now go on to talk about. These have been created to provide a regulatory platform for leaseholders to address their complaints. This requirement to belong to a regulatory body was introduced by the Redress Scheme for Letting Agency Work and Property Management Work, requirement to belong to a scheme, etc., England Order 2014, which came into force on the 1st of October 2014. This order has now made it a legal requirement to belong to such a scheme, and it sets out any exemptions to the duty to belong to the scheme. The Department for Communities and Local Government intend that the property management companies which are set up and owned by freeholders and which only manage freeholders' property will be exempt. There are 3 government-approved schemes which I've listed on the slide along with their websites. They are the Property Ombudsman, Ombudsman Services, and the Property Redress Scheme. Now, these three bodies have enough capacity to take in the approximately 500 managers who have not previously voluntarily joined a redress scheme. So, as of the 1st of October 2014, any person who engages in property management work must be a member of an approved or designated redress scheme dealing with complaints in connection with that work. Now, there are some exemptions from these rules, which include landlords, which, although not explicitly excluded, they are not actually generally covered by the definitions as they're not acting on instructions from another party. Local authorities are also exempt for the reasons, as I mentioned earlier, they're already subject to the Housing Ombudsman, right to manage companies, and also those authorised or licensed to carry out regulated activities under the Legal Services Act 2007. Now, please bear in mind that this list is not exhaustive. There are a few other exemptions out there. The legislation is intended to offer accountability and justice via the approved redress scheme providers. If a complaint is made against a scheme member and it's upheld, then redress schemes have a number of options. They can either require an apology, issue a reprimand, order compensation. The amounts for compensation are capped at £25,000, but if an aggrieved party wishes to claim more, they would need to then apply to the courts rather than the redress scheme. They can also fine a member. Now, again, be aware that the monies recouped through these fines do not go to the leaseholder, it would go back to the scheme. And they can also expel a member. Now, if a member is expelled, then it's likely that they'll be refused access to memberships of another scheme. And if no scheme will accept them into membership, then they could not then legally operate. Members of a redress scheme are bound by the scheme decision, but complainants do not have to accept that decision. They can go to court instead if they are not happy with that outcome. There is a requirement to belong to a redress scheme and a process for ensuring compliance with a fair and effective penalty. The Enterprise and Regulatory Reform Act 2013 reformed the regulatory environment faced by small and medium-sized businesses and provides for orders to be made making provisions for sanctions for any breach of the legislation. Local authorities have a duty to enforce this order and can impose a fine of up to £5,000 where a letting agent or property manager who should have joined a scheme have not done so. They must be satisfied on the balance of probability that someone who has engaged in property management work and is required to be a redress scheme member has not actually joined the scheme. The local authority must give written notice of their intention, setting out reasons for the penalty, the amount of the penalty, and also explaining that there is a 28-day period in which they can make any written representations or objections from the date that they receive that notice. The written notice must be served within 6 months of the date on which the authority is in a position to issue the fine. After gathering enough evidence and satisfying any internal requirements that a fine is appropriate. After the 28 days has passed, the local authority must then decide whether or not to impose the fine with or without any modifications. If they do decide to go ahead with the fine, then they must serve a final notice, which must include any reasons for the fine, the amount to be paid, how payment must be made, and give them a period in which they can make that payment, which would be no less than 28 days. They also need to ensure that they include the consequences of failing to pay the payment, and also give them a right to appeal and outline the consequences of non-compliance with the notice. If a property manager wants to appeal against a final notice, an application to the first tier tribunal property chamber should be made within 28 days of the day on which the final notice was sent. An appeal can be made on the following grounds: error of fact, if something was wrong in law, if the amount of the fine was found to be unreasonable, or if the decision was unreasonable for any other reason. The tribunal has the power to quash the final notice, confirm the final notice, or vary the final notice. If the fine is not paid, the local authority then needs to get the permission of the court in order to recover the fine, which would then be enforceable as a court order. The local authority's chief finance officer must sign a certificate stating that the amount due was not received by a date specified in the certificate, demonstrating conclusive evidence that the fine has not been paid. At any time, the local authority may give written notice to either withdraw a notice of intent or final notice, or reduce the amount of the fine in either notice. If a property manager then fails to join one of the redress schemes after the imposition of a fine, a local authority can impose further penalties despite already having a penalty imposed. There's no limit to the number of penalties that may be imposed on an individual lettings agent or property manager if they continue to fail to join a scheme. So, looking to the future, there is a review planned once approved schemes have been operating for about a year to ensure that they are actually working as planned. This gives the Secretary of State some time to request any changes as to how the schemes are operating, if that is deemed necessary. And it's currently anticipated that the first review will be conducted around the autumn of 2015. However, the review may be conducted earlier if the Secretary of State considers it appropriate to do so. Thank you for listening. As I mentioned at the beginning, if you have any queries, please email us or give us a call. Thank you.